Good, buddy. This is Michelle with Commercial Investigations. How are you all?
Good.
We're just waiting another minute or two. There's a couple more people probably join us. Okay, good morning, everybody, again. This is Michelle. I'm President of Commercial Investigations. This time I'm going to mute the attendees. Please unmute yourself if you have any questions. We like to have an interactive presentation, but we get background noise if I don't mute you. We're going to talk a little bit about Article 23A of New York Corrections Law. It's actually going to be a review in light of the March 13th Attorney General's Agreement announcement with background check agencies to end illegal hiring practices. So we're going to get into that a little bit and give you some background and then talk about Article 23A. Cordiola is having technical difficulty at this point in time. She may be joining us shortly. For you who are unfamiliar with Courtney, she's been with us since December. She's a client services specialist. Courtney Masters in forensic psychology from the College of Criminal Justice. She serves as an investigator with the federal government conducting background investigations, and she has a total of over 12 years working with the government agencies in various roles. Courtney reached at our 800 number, extension 214, or Courtney Kayla at commercialinvestigationsllc.com. I encourage you to reach out to her should you need anything. I myself am also available. I had started commercial investigations in March of 2004. We just celebrated our 10th birthday and are all excited about that. I am a licensed private investigator in the states of New York and Florida. And my first background check in 1991. So I'm in and around the industry for quite a while. My extension here at the 800 number is 202 and can be reached at Michelle Pyan at commercialinvestigationsllc.com. So we're a woman-owned New York State licensed private investigative agency. The mission is to be the most innovative and educational background investigations partner. Eric Schneiderman, the New York Attorney General, announced that he had agreements with background check agencies to end illegal hiring practices. Actually, industry transforming agreements, and the agreements were with 4 of the top background screening companies as far as volume goes. So I've heard of HireRight, First Advantage, GIS, and Sterling. So I'll tell you a little bit about what instigated this amendment that the Attorney General came in doing recently. Companies, along with others in the industry, have developed technology that allows employers to have parameters, which indicate when somebody has an acceptable background or not. So it becomes a very automated process. So an employer may say, well, we won't do with and somebody came up with a felony conviction, and these 4 background screening companies were processing it. They automatically send that person a pre-adverse action notice and never really look at the report from the client side, being your side of our company. In New York State, we can have blanket policies regarding criminal convictions. We can't say we're not going to hire somebody convicted of a felony. Article 23A requires us to look at it on a case-by-case basis. And just a little side note, I want to mention that Article 3A is very closely linked to what the EEOC recently put in place with its guidance in criminal records for all U.S. employers. Now, the EEOC is simply guidance, not law. Like in New York State, Article 23A is a law. We have to comply with that. But the EEOC is trying to get employers across the U.S. to implement similar procedures. The Attorney General of New York, being that we have the law here, Article 23A, sought to get these companies to stop doing their illegal practices of having this automated system. They signed agreements, and that was all announced March 13th. Schneiderman states that the law requires those who pay their debt to society to receive equal access to employment opportunities. Okay. Now, a little bit about Article 23A. If you looked at it recently, Article 23 is simply a little bit more than 1.5 pages of text. It's a very short section of the statute. But it requires that employers consider a number of mitigating factors in hiring decisions based on criminal history. So we'll talk a little bit about those mitigating factors. So I'm going to just go through Article 23A here. Some parts a little more quicker than others. As statutes, it starts out with some definitions. And further at the definitions, we see that this applies to public agencies, private employers. It talks about direct relationship, which means the duties and responsibilities of the job, having a direct relationship to the condition and the fitness of the person's ability to do the job because of that condition. The statute also covers licensure by the licensing agencies in New York State, and of course, employment. So public employers in the means of employment have to comply with Article 23A. We pay much attention to the licensure issue, the agencies issuing licensure. But employment for our purposes means the hiring of individuals, just like we all do our employment purposes. To remember, there's nothing in Article 23A that affects your right with respect to intentional misrepresentation in connection with an application for employment. What it means is simply that somebody falsify documentation in the hiring process. That right. It is your right at that point to not hire or give that person the opportunity they applied for. Thing that, you know, if somebody misrepresents themselves, you take action as you would because it's an intentional misrepresentation. Okay. On who discloses information which is validated by a background check that we may for you, then Article 23 comes into play. So one of the first things you want to do is make sure somebody didn't misrepresent on their application should you have questions about criminal history, or our consent form where we ask the questions about criminal history. So if you misrepresented and said, no, they were not convicted of crime, and we report a criminal conviction, then you do not have to follow Article 23A because they have a misrepresentation there. So it's unfair discrimination against persons previously convicted of one or more offenses is prohibited. So the unfair discrimination, well, they require us to go through a set of criteria to determine, and this is on a case-by-case basis. So if the direct relationship between more of the crimes in the employment sought, you may not need to hire them. Okay? And also, you have to consider the unreasonable risk to property, safety, and welfare of specific individuals or the general public. If you can show that direct relationship between the job duties and the convicted, as well, or instead of you go unreasonable risk to property, safety, or welfare of specific individuals or the general public. So if you show those two, then you do not need to hire the person. But again, you have to look at it on a case-by-case basis in order to get to that point. That comes up a lot as people talk about the 8 factors. In 753 of Article 23A, talk about the 8 factors that you must consider. Okay, so we need to consider of the state as expressed in this act to encourage the licensure and employment of persons previously convicted of one or more criminal offenses. This exists in order to express that the state encourages employment of such individuals. Then the second is the specific duties and responsibilities necessarily related to the licensure or employment sought and held by the person. And here this comes to the comparison of what was the criminal conviction and how does that relate to the specific job duties. Your job descriptions are important. If any, that the criminal offense or offenses for which the person was previously convicted will have his fitness or ability to perform one or more such duties or responsibilities. So one item on a job description that directly relates to the criminal offense for which the person was convicted, say the person responsible for making deposits after the restaurant closes at night. Well, right there, the person was convicted of, let's say, petty larceny, right, your direct relationship. Unfit for the job. The time that has elapsed since the occurrence of the criminal offense or offenses. So how long ago did the person commit that criminal offense? And then let's consider the age of the person at the time of the offense or criminal offense. I read about recidivism rate, which is where people they commit time after committing a first crime, the time frame that evolves between the two, and other things along the lines of criminal studies. In today's society, an individual between the age of 18 and 23 has a 80% chance of being arrested. Now that's arrested, so a certain percentage of those are going to end up being convictions, which you're going to deal with from employment perspective. Now the convictions from when the person was 18 to 23 years old. If a person today is 25, that has much more of a bearing on the job than if, say, that person today is 35. So that's what they're getting at here. The serious or offenses. In the penal code is broken down into felonies and misdemeanors. You have 4 felonies, Class A being the severe, down to Class D being the least severe. And when it's the misdemeanors, you have 5 levels of misdemeanors, with misdemeanor of Class A being right below the felony of Class D, and the misdemeanor of Class E being the lowest level. The least severe crime in New York State is a misdemeanor of Class E. produced by the person or produced on their behalf in regard to their rehabilitation and good conduct. Okay, so a judge can't issue rehabilitation paperwork. But it does happen. So if an individual produces rehabilitation paperwork, you need to consider that. It doesn't have to hire them. It means it needs to be one of your considerations while you're going through this case-by-case analysis of that individual and the past criminal convictions they have relate to the job duties. So, interest of the public or private employer in protecting property and the safety and welfare of specific individuals or the general public. This is a pretty one to hone in on. The majority of our clients, over 70%, probably getting close to 80%, are nonprofit organizations. They deal with children and vulnerable populations. You have an interest in protecting the safety and welfare of those specific individuals, of your clientele, the people you treat. If your interest outweighs the interest of giving that person a job, you do not have to give them the position that they applied for. So keep this one close. This one is relied upon a lot. The chapter goes and re-emphasizes that a certificate of relief or certificate of good conduct that the applicant gives you needs to be considered when making these determinations. It doesn't have any details beyond that point, but it just indicates that you need to take that into consideration. So you had two individuals with the same criminal, the same job that they're going for, and one of them had a certificate of relief or a certificate of good conduct. You consider that versus a person because it's something different. People don't need to give that in the position. Okay, but do pay attention to anything that a subject may give you. Now, talk a little bit about a certificate of good conduct. Sometimes people just give you brief letters, information from, say, some volunteer experience they did, different things like that. That can be considered information to their good conduct. So don't dismiss it if it doesn't look like an official document. Time though, you're going to get the official certificate of relief if it's into play. One thing to also consider under this Article 23A is that if the person's been convicted of a crime and they request from you, now it doesn't say they have to request it in or anything, and I have a request to you, within 30 days you have to give them a written statement as to why they were denied the position. Now, this existed prior Reporting Act, and as you know, if you hire somebody based upon our report, you do pre-adverse adverse action. And with pre-adverse adverse action, you're giving a copy of that report, and the person is getting information. So I believe that people requesting a statement from you as to the denial drastically decreased because of the adverse action under the Fair Credit Reporting Act. But just be aware that this is another requirement. Okay. Forced by the Division of Human Rights and in New York City, the Commission on Human Rights. It is a very good guide that my colleague found. Lund found this for us. It's a guide specific for New York employers, and the URL is on top there. If to write that down, we do anticipate having this presentation up on SlideShare within a couple of days, if not this afternoon. But if you do Article 23A and Hiring Guide for New York employers, you should find this document. Now, in this document, they give a couple of illustrations. And we find this very interesting because they give their nice picture with a little scale weighing between hiring and denying. And they showed an analysis for somebody convicted of a third-degree burglary who wants to be a short order cook at a hotel and restaurant. Some considerations that were taken into play is 5 years have lapsed since. They got a positive letter from the counselor. There's your certificate of good conduct. No violation involved in this offense. It was burglary. Nobody got hurt. There was no physical violence. New York public policy encourages that these people be given an opportunity, and has no bearing on the ability to perform the duties of the job. So on the deny side, you got the applicant was 35 when he did the job, crime, excuse me, a little older. Crimes of non-repetitive and others occur in their early 20s. Burglary is moderately serious. That's a pretty good level burglary. So it's quite a bit of property, and there's some interest in protecting property of the hotel and restaurant that is involved here. So those landed on the deny side, but the high side outweighed that. So it shows a case-by-case analysis. There's 3 of these case-by-case analysis that are shown within this publication. So I encourage you to go ahead and take a look at that. Because we have pretty graphics like that and a lot of time to really put them together, we created for our clients as a spreadsheet. It's a matrix. And actually outlines Article 23A that we just went over, the criteria. It indicates a spot for you to put the CI request number, so you don't have to put personal identifiers of the person. If you put the request number, then you can come back to it later within our system. So do your case-by-case analysis for each person on each row here, and generally start to accumulate your organization's decisions based upon the criminal history you've gotten, so you can make sure you're not discriminatory backwards based upon past decisions you've made, and you can ensure on a case-by-case basis all of these different elements were looked at in relation to that particular individual and the particular crime that was convicted, a job that they've applied for. Okay. Anybody who wants this spreadsheet of Article 23A, please just email us. We'll go ahead and send that to you. It's an Excel spreadsheet. We just basically took that and we put a couple extra in so that you could document a little bit more detailed information. Put it in an Excel spreadsheet. A caveat, I am happy to announce we are not lawyers, so we cannot give legal advice. However, we can certainly put a matrix together for you and hand that out for you to use as you wish. You may want to consult legal counsel. Okay, I want to point out that there's notice and posting requirements. Article 23A kind of got a rebirth in 2009. What happened is they snuck a statute in under employment education. And under the employer education requirements of the statute, it referenced Article 23A and now made notice and posting requirements mandatory for New York State employers. And this was effective in 2009. So Article 23A has been around, oh, I don't know, maybe even the 70s. So it's been around a long time. But the legislature found that employers were really kind of wanted to bring it back to light. On its face, it's still a good statute. So they implemented notice and posting requirements. 9 of ours, you have access to our client page. And you find our consent forms and you find our Article 23A poster. So you look at the last pages of our consent form, you're going to see Article 23A connected to our consent form for New York employers. There takes care of your notice requirement. The law requires you to give notice to anybody convicted of a crime. Well, you don't know till after the fact, but we attach it to the consent form, so you give it to everybody up front, and you're covered, and you're actually giving more notice than required. But it makes the process and procedure a lot easier and more manageable. And you're required to post Article 23A. So we took the law and gave it a little header footer and put that for you to print. You post Article 23A where you post all your other employee postings. So you put a break room. You know, a lot of people convicted of a crime may never get into the break room to see it because you may not hear them. At least you've posted it according to the law. And you post it with other postings. So you can get that off our client page. If you're having trouble or need assistance with either of those, just give us an email or call. You know, due diligence, and due these days is carrying quite a bit of baggage with him. Due has a report out there on our web page. If you go to the website, you click on Due's page, look for report that ends in 4588. And what you want to do either individually or within others within your organization, you may get that spreadsheet from us, pull up this report with Due, and really work through it as a group or as an organization to help you realize what kinds of decisions you're going to have to make and to prepare you for when you do get that report that has that criminal record that you have to go through and make a case by case and emphasis on whether or not you're going to hire the person based upon New York State Article 23A. This exercise you could do internally if you'd like. I know I've covered a lot of information in a very short period of time. I am going to unmute everybody now and have a little question and answer and discussion about what we just talked about. All right, questions out there?
Hi, this is Carolyn from Bassett. I don't have any. You did a very nice job, Michelle, in covering issues.
Thanks, Carolyn. I appreciate that.
And get in touch with you if we have any.
Yep. Good point there. So, here's our contact information again. Anybody else have any questions, comments, or anything we can help them with today while we're online? Well, if you have a case-by-case analysis that you need to do and you would like assistance, I encourage you to contact me or Courtney. If you feel that we can help you, we would be pleased to look at that with you and go through the analysis. With that, we'll end the webinar today. Thank you for your time and your business, and I wish you all a happy and safe Easter weekend.
Thank you.
Michelle, see you.
Bye.
Bye.